Hello, everyone. Again, I'm Professor Robert Romano, and this will be beginning our second week of the sports law course here at St. John's University. This week, we're going to go over an overview of the American legal system. We're going to talk about the functions of our law, where we get our law from, and the difference between civil and criminal law. This week, there are two postings on Blackboard I'd like you to read. Number one is the Roger Clemens indictment, and the second one is the Michael Vick plea agreement. I will also be posting other articles as the week goes on, so always check. Also, during this week, there'll be discussion questions on both the Michael Vick plea agreement and the Roger Clemens indictment. And there'll be discussion questions on other postings that happened during the week. One of them is, I'm assuming, will be the decision by the NFL as to how and if they will be punishing the New England Patriots for the deflated balls during the AFC Championship game. First, though, what is law? What do we mean by that concept? I want you to think about that. We know what law is. We follow the law, hopefully. But what does it mean? What would be a definition that you would feel comfortable with? The standard book definition of what law is a body of rules of action or conduct prescribed by a controlling authority that have binding legal force. So it's a body of rules, or rules, regulations that tell us what we can and what we cannot do. They are given to us by a controlling authority. What does that mean, controlling authority? Usually that means the government, the federal government, state government, and your local government. And they must have binding legal force, so there must be some consequences attached if you do not follow the rules of action or conduct. They must be obeyed and followed by the citizenship, or you'll be subject to sanctions or legal consequences. What is the function of our law? What function does law have on our society? Why do we have laws? Most of the time, it's just to keep the peace. We don't want criminals. We don't want criminal actions taking place. We want to keep law and order. We don't want to be robbed on the streets because there's no consequences. We don't want to be beat up on the streets because there's no consequences. So one of the functions of law is to keep the peace. The second one is to shape morals. In this country we have drug laws. We have alcohol laws. You cannot drink until you're 21. You cannot take illegal drugs at all. In some states, it is now legal to purchase and smoke marijuana: Colorado, Washington, Alaska. But sometimes our government feels necessary to say we can or cannot indulge in certain activities. Social justice, human rights. Want to make sure that everyone's treated fairly. That's another function of our law. We also want to keep the status quo. We don't need to have our government overthrown every 2 years. The function of law is to keep law and order. This doesn't mean we shouldn't overthrow our government. Thomas Jefferson said we should do it every 20 years, but we need to keep to some form of normalcy that would facilitate order in our life. Another function of the law is to help plan our society. We don't want high-rise buildings in the middle of farmland. We need to have structure. We need to have zoning rules. We need to have everybody driving on the right side of the road instead of the left side of the road. This is in England, We don't want to drive in England. Laws are also a way for people to compromise. It is estimated that over 90% of all cases that go to court settle. All right, so the courts and the laws act as a way to facilitate compromise. And maximize individual freedoms is another function of our law. We have religious freedoms in this country. These are given to us by the Constitution that we have, the U.S. Constitution. We have freedoms of speech. We have freedoms to assemble. These are all the function of our laws. And also, we need to understand that our law is always changing. All right, it's always evolving. It's always growing. 100 years ago, some of the rules that applied may not apply now. So a rule of law is constantly growing, constantly changing, and constantly adapting to our current society. But that begs the question, where do we get our law from? What are our sources of law? We have in this country we get our law from basically four, arguably six different areas. One of them is the common law. Second one is constitutional law. Third is statutory law. Fourth is administrative law. And then arguably we get law from executive orders and from treaties. So in the United States, we get our law from basically six different areas. Law that we need to follow, for the most part. The common law. What is meant by that term, common law? We've all heard of it. We all know kind of what it is. But I want you to think for a second, what is meant by that term, common law? Well, what common law is, it's a system of law derived from centuries of general rules, customs, and experiences. It derives, we got this from the English. When we established our country in 1776, one of the first things we did was to adopt all the English common law, all of their general rules, all of their general customs, and all of their experiences, and make that our law. Common law is based on a series of judicial decisions. They're rules based on decisions of actual legal disputes that previously happened. So, our common law comes from England and is based on actual legal disputes. Under the common law, decisions of numerous courts over hundreds of years are combined. All right, so when judges are on the bench or judges are making decisions, or when lawyers are arguing their cases in the courts, they argue based on this term called precedent. Okay, there are cases out there that we must follow. Once lawyers, we follow these, and judges, they have to follow them, because once a case has been decided at a higher court level, say an appellate court or Supreme Court, all analysis by the local courts in that jurisdiction must rely on those prior decisions. So we build these case laws, and as they grow, all the lower courts have to follow the rulings, holdings, or precedents of the higher courts. This term of art is called stare decisis. It's the practice of courts following case precedent or prior legal cases and rendering their opinions. What the term actually means is to stand by the decisions. Stand by the decisions of the higher courts. And that basically, in a nutshell, is the common law, one of our sources of law here in the United States. A second source of law is the Constitution, or constitutional law. Think for a moment, how many constitutions in the United States do we have? It's an interesting question. Do we have one, the U.S. Constitution, or do we have many constitutions? In actuality, we have the United States Constitution, which was established in 1787, and we also have 50 individual state constitutions. So, the U.S. Constitution was established in 1787, became the supreme law of the land. 4 years later, adopted to the U.S. Constitution was what become known as the Bill of Rights. Okay, the Bill of Rights was tacked on or added to the original Constitution because at this time people expressed the fear that our new federal government, the new government of the United States, would abuse its powers. Therefore, the Bill of Rights was established to limit the powers and authority of the federal government and guarantee civil rights and protections to the populace. So think about that. The Bill of Rights limits the power of the government, not the power of the people. The Bill of Rights gives the power to the people and limits the power of the government. Okay, so these are your rights. These constitutional rights are your rights. And when I say constitutional rights, what am I talking about? What rights am I talking about? Amendment number 1 that we have in our Constitution is the freedom of religion, freedom of speech, freedom of the press. In this country, we have a right to worship with any church that we please. It's our freedom. We have a freedom to say anything that we want under certain context. And the press, our newspapers, our ESPNs of the world, have a right to say whatever they want to say without fear of government intrusion, as long as it's true. All right, they can't go out and defame people. They can't go out and say mistruths, even though we have Fox Sports. But we in this country, our First Amendment guarantees a right of religion, a right of the press, and a right of free speech. The Second Amendment is right to keep and bear arms. The NRA people are big fans of this amendment, the right to keep and bear arms. Some of our other amendments are the protection from quartering troops. It's an important one, I know. When we first started this country, when the British were in charge, they would impose their will upon the people by having them quarter and feed troops, British troops. So when we established our new country, we felt that this was important, that the people of the United States would be free and be protected from quartering troops in the future. The Fourth Amendment, my favorite amendment, is protection from unreasonable search and seizure. The government cannot search or seize anything from us unreasonably. And what that means, we'll get into at a later time, but means that they cannot do such without probable cause and or a warrant. Another one of our amendments is the right to due process, a right against double jeopardy and self-incrimination, and a right for the government to have eminent domain. Again, we'll go through these in more detail as the course goes on, but right now, under our Bill of Rights, we have a freedom of due process. We have to be supplied due process. We have a right against double jeopardy. What that means is once you've been tried for a case and you're found innocent, you can never be tried again. So think about this in the OJ context. He's found innocent of murdering those two people. He can come out and say that he did it. It doesn't matter. He can never be tried for those crimes ever again. We also have a right against self-incrimination. Right not to say anything. The right to lawyer up, as I like to say. You ever hear the Miranda rights? You have a right to remain silent. You have a right to an attorney. Those are your rights against self-incrimination. Under the Bill of Rights, we also have a right to speedy trial, right to counsel, the Confrontation Clause, which means you have a right to cross-examine your witness, anybody who's going to witness against you. You have a right to a jury by trial, and you have a right to be free from excessive bail or cruel and unusual punishment. So, under the United States Constitution, you have certain rights, which were your first 10, certain rights under the Bill of Rights, which were the first 10 amendments to the Constitution. Since that time, other amendments have been added. We won't go over those today, but certain rights have been added, such as the right of equal protection, the right to be free from slavery, the 13th Amendment, and so forth. Under the Constitution, the legislature was given powers to enact laws. The executive branch, or the president, or the local governors were given the powers to enforce laws. And how do they enforce laws? How does the executive, or the president of the United States, have the power to enforce a law? That's easy. He's the commander-in-chief of the Army, Navy, Air Force, and Marines. So if you do not follow, he can call in his resources and make sure that you do. And the judicial, or the courts, have the power to interpret and determine the validity of a law. That's their role. Congress enacts, president enforces, and the judges are there as a catch-all to interpret and to determine that this law is constitutional and that this law is valid. It isn't against public policy. The Constitution, under constitutional law, each state has their own constitution. Each state's constitution can give you more rights than our U.S. Constitution. They just cannot take any away. So, those are our two sources of law so far, the common law and constitutional law. Our third area is called statutory law. This is written laws that have been established by our legislature. All right? They control a course of conduct that parties must adhere to. enacted by your legislative bodies at both the state and federal level. State and federal legislatures enact laws termed statutes, while your cities and your counties, your local counties, that when they create a law, it's called an ordinance. All right, so you must remember that statutory law is only valid in the area governed by that entity. So in New York, you only need to follow New York laws. In Connecticut, you need to follow Connecticut laws. They may be the same, but they may be different. But if you're in New York, you only need to follow the New York law. You do not need to follow Connecticut law. And just be aware that when jurisdictions overlap and conflicts arise, federal law always prevails over state law. State law always prevails over your local law, your ordinances. And nothing, no statute can violate or take away any of your rights guaranteed under your state or U.S. Constitution. So, 3 areas of law it's gone over so far. Common law, the constitutional law, and statutory law. Our 4th area of law is administrative law. This is where the administrative law is law where administrative agencies are given by statute certain decision-making power to enforce certain actions. Administrative agencies are specialized bodies created usually by federal or state statute, and they're granted certain lawmaking authority to regulate certain activities. So it's very narrow. Administrative agencies' power is very narrow. Think about this. What administrative agencies are out there? Well, the National Labor Relations Board is a huge one. The Internal Revenue Service, right? They're given special powers to enforce tax laws. If you do not file or pay your taxes, you may be subject to sanctions, or you may even go to jail. This is power that they've been given. OSHA is a huge administrative agency. They have the power to make sure that work sites are safe and that the employers are following certain codes of conduct. The FDA, the Food and Drug Administration, or the FAA, the Federal Aviation Committee. These are all administrative agencies which are given by statute certain powers to regulate certain activities. The 6th area of law is executive orders. The president and the governors have some implied powers from the Constitution that allow them to give certain orders in certain situations. The situation that I always try to example is the fact that under former President Bush's reign, he was made executive orders that was implied from the Constitution where he developed the Department of Homeland Security, which is still with us today. And our last area or source of law is treaties. All right, treaties really don't affect us on a day-to-day level, but the U.S. Constitution provides that the president, with the advice and consent of our Senate, may enter treaties with foreign governments. So, these treaties are considered the law of the land and must be followed, but on a day-to-day basis really don't affect us all that much. So, under our form of government, we get our power, our law from four to six different areas. I always say 4 because there's 4 dominant ones and 2 lesser ones. Those 4 prominent ones are the common law, the Constitution, both U.S. constitutions and the state constitutions, statutes, and statutory law, which are enacted by state, local, and federal governments, and administrative law. The 2 other areas or sources of law come from executive orders and treaties. This is the first part of the lesson for this week. Should you have any questions or concerns about anything that we discussed today, please feel free to reach out. But as of right now, this is what we'll go over. I'll be posting a second video during the week going over the difference between criminal and civil law. But now I just want you to think about what we talked about with regards to the functions and sources of law. Thank you.